All right, welcome everybody to this is business law covering um, secured transactions under the UCC. Remember, we've talked about in this section, the first part was the UCC regarding consumer goods, and this is the secured transactions on those consumer goods. Secured transactions means and actions in which I'm agreeing to basically loan you something, right? You may get a car, but you're going to agree to pay me back money. I'm loaning you the money at this point in time to get that car. Sometimes it can be directly, right? Sometimes you may do a loan from the car company directly. In some instances, it may not be. There may be a bank that ends up taking over that, but it's still a secured transaction, right? The second video, I've broken down this area. The second video is going to be the bankruptcy part of this. One, I wanted to keep them shorter. I just think it made more sense to separate the two out. I will tell you a caveat. This part of UCC when I was in law school was the one I dreaded and hated and hoped that there wasn't any questions that really came up on the bar exam, and there was a few, but not as bad as I had envisioned in my head that it was going to be. Anyways, so not fond of teaching it, not fond of learning it, and I apologize if anything comes unclear. It's just one of those areas where it's just very definition defined, and there's not any rules or principles per se. All right, so with that in mind, I do have some reminders about what's coming up. Remember, our test is not this Thursday, but the next Thursday is when our test potential will be. We've talked about moving it a little bit, and I'm still waiting to get final feedback from everyone on when that might be. But no matter what, extra credit papers and ethics papers are due on May 7th, that Thursday, which our exam would otherwise be, by 6:30 p.m. I still want those in so I can kind of start to get those graded in if we move the exam to a different day because it works better with everybody. All right. I will do my best here within the next few days to get out study guides for you all so that you can get prepared for that last test as well. Evaluations are available to you all. Again, I do read them. I like constructive criticism. I think this is going to be a weird semester, but I still like constructive criticism and highly encourage you to do those evaluations. Okay. With that, that gets us into secured transactions. As I told you, it's a very definition is what it's all about. And if you know the definitions, you're good to go. Here are some of the basic definitions. Fixtures, goods that have become attached to real property or real estate, right? So for example, your hot water heater, it was a good when it was sold to you, but once you affix it to the house, it becomes a fixture. Air conditioners are a lot of times are that way as well, right? Those are called fixtures. Security interest is an interest in personal property or fixture that is used to secure some obligation, right? So, for example, if I go to buy an air conditioner, $5,000 air conditioner for my house, I may enter into agreement to pay monthly payments to the air conditioner company. That's a secured interest. That contract that we come up with is a secured interest contract. So I am agreeing to pay for the air conditioner, and they're going to be able to take that air conditioner as if I don't pay for it, right? That's a secured interest. Now, once it becomes attached and fixed to the house, it cannot be separated from that house on a different, say for whatever reason, I had a car loan and they wanted to come get my hot water heater air conditioner. That doesn't happen, right? A secured party is the person or company that holds the security interest. So in my scenario, the air conditioning company would be the person holding the secure interest. The collateral is the property which is the subject of that interest. The air conditioner would be the collateral. Debtor is the person who owes the money for that collateral, right? Person who originally had ownership interest in the collateral. Obligor is a person who must repay. Now, they aren't necessarily the same, right? If my parents agreed to pay for the air conditioner, They might be the actual obligor or cosigner or something in that situation. So not always is the obligor and the debtor one and the same. A security agreement is that contract we talked about in which the debtor agrees to give the security interest to the secured party, right? Whatever money, whatever it may be. Default, where the debtor or obligor failed to pay money or fulfill their obligations under that security agreement. Repossession, we all know what that is. In some situations, maybe on my air conditioner, they can come in and in the middle of the night take my air conditioner when it's 105 degrees out, and all of a sudden I have to get too hot because I haven't paid for my air conditioner. Perfection are the steps that must take place before that security interest is perfected. The key to that being perfected and what that means is really going to come, you'll understand more when we get into the bankruptcy part of this, because what you really want to do is become a secured interest person, because you then become priority over those priority claims that are established by the bankruptcy code and unsecured claims, right? You get the highest status when you're a secured interest. And perfection of the steps taken to basically notify people out there, I have an interest in that, whatever it may be. A financing statement is a document used to perfect that. A lot of times, in some situations we'll talk about when it comes to consumer goods, those can perfect automatically. And in other situations, it might have to be a financing statement filed with the Secretary of State's office. All right, scope of Article 9, which is the secure transactions article. Any transactions intended to create a security interest in personal property or fixtures. Again, nothing to do with property. We're still talking about goods in this situation. Types of collateral. It can be personal property, goods, cars, jewelry, fixtures, any of those. Instruments are drafts, checks, certificates of deposit, notes, stocks, bonds. Again, you don't need to know necessarily what each and all these are. Just understand that they're called an instrument. Investment property, again, I don't need you to know about what that is. It's only the security interest in the property, not the property itself. Right? Say there's a mortgage on the property, you own the mortgage on the property, that's an investment property. That's something that can, in fact, have a secure transaction. Documents of title, right? Way to show ownership. Those are the different types of bill of lading or warehouse receipts. These are indicating that you currently have possession, even though somebody else actually has possession of them, these are currently owned by you, are those different types of documents. Accounts, think about receivable, the right to receive payment for something. That's something that can be used to secure a loan, right? Say, for example, I have a business and a restaurant business, and people owe me money. So I have a bunch of accounts receivable. Maybe I do a lot of weddings or something like that. So people owe me money from all those. I need to get a new refrigerator unit to run my business, my restaurant business. I can go to the refrigerator company and use my accounts receivable as interest. My future money that's going to come in these accounts receivable is what I'm going to use to secure that refrigerator, right? Deposit accounts, money placed in the banks. Commercial tort claims, just the idea of if I've sued somebody because they wronged me, those can be used as security interests as well. General intangibles, it's kind of the catch-all sort of copyright, patents, trademarks, goodwills, all those kind of things can be used. Chattel paper, the recordation or obligor owing money and a security interest in the property. That's all that, right? Banks, mortgages, that's all that money. Even though the property itself can't be used as a security interest under the UCC, the fact that you are owed money on those mortgages is considered chattel paper and can be used. All right, types of collateral. We've talked a little bit about that. Goods, consumer goods, is the primary. You got to know this definition. The primarily for personal, family, or household purposes. A consumer good under the UCC. Again, primarily for personal, family, or household purposes. Farm products is different, right, than consumer goods. crops, livestock, supplies, and any of the supplies used directly for the farming, your plows, right, your tractors, those kind of things. Inventory, goods held by someone for later sell or lease. Equipment, items particularly used in running a business. Software is a tricky one. If software can be used as part of the good, it's usually considered a good and considered part of that particular good. If it has a proprietary interest, then it's considered software, and that is different. That's not a good. So attachment of a security interest. Again, the key to this is it'll make more sense, especially when we get into the bankruptcy code. But these are the steps, requirements that are needed to show that you have a secured interest that gives you priority over different types of claims under bankruptcy. It's a three-step process. One, parties make a security agreement. Think about that being a contract. That's really what a security agreement is. I'm agreeing to give you this collateral, whatever it may be, and I have an interest in that collateral, and you're agreeing to give me something in exchange, right? And we're using one to secure the other. The debtor has authenticated a security describing collateral, or the secured party obtains possession or control of collateral. Possession is the #1 way in which you can perfect your interest in something. If you have it in your hands, it's right. You can clearly demonstrate that you have a security interest or some sort of interest in that. Otherwise, how would you or why would you have whatever that particular is, unless you're fraud, stolen, or something like that? That aside, when there's clearly an agreement between parties and you have possession of that, it makes it pretty clear that you have an interest in that particular, a security interest in that, right? Possession is always one of the best. Control and possession is one of the best. But not always can that happen, right? But secured party obtains possession or control of the collateral. 2, secured party has given value, right? So the secured party, say an example of the air conditioner that I've talked about, they've given me the air conditioner, right? They're going to end up being the secured party in this situation. They have given me the air conditioner. And last, the debtor has rights to that collateral, right? I'm going to be able to show, yeah, I've got rights to this particular collateral that I'm using, if it's money or whatever it may be. And sometimes maybe on that air conditioner, we used something that I have, accounts receivable or something I used to secure the interest in it. Right? I have to show that I had rights in whatever that collateral that I'm going to be using is. All right, the agreement usually is generally in writing and acknowledged in some way by the debtor, right? Think about in contracts, the defendant has to have signed it. That's usually what has to have happened in a security agreement as well. Must reasonably identify the collateral, right? There has to be some idea of what that collateral is, whether it's the air conditioner, whether it's the accounts receivable, whatever it is. There used to have to be some reasonable identification of what it is. If it's a consumer good, the description must be fairly specific. Right. Generally state what the default is and what the remedies for a default may be, right? Repossession may be essentially what one of the remedies is. But the security agreement needs to outline what that might be. There also may be some general things like, for example, on cars, right? You have to have insurance on those cars by the time of the loan, right? And so if you don't have insurance on that, you may be defaulting on that security agreement, and therefore there may be some remedy. Control. Again, we talked about it. If the secured party has either control or possession over the collateral, control is different from possession, right? Possession, clearly, right, I got it. It's in my safe, whatever it may be, but I've got it. Control may be different. It may be some place completely, but I have paperwork that says I'm the one that's in control. I could dictate it getting moved from one place to another, whatever. I have control over that. Even though I may have possession of it, I have control over it. A lot of times you'll see that when it comes to money. In fact, money, it has to be that with deposit accounts, right? I have control. I can tell the bank, it's in a bank, but I can tell the bank to give $100 to somebody, right? I have control over that bank account. If the secured party has either control or possession of a collateral, the agreement can be done orally, right? It's clear. I have possession. I have it, right? There's not an issue, right? Security interest attaches if the secured party has control of the following types of collateral. You don't need to know these, but this is kind of what we just talked about. Deposit accounts, chattel paper, that's that paper talked about exchanging of money, investment property, letters of credits, etc. All right, those have to be done by being in control or possession. All right, for possession, security interest attaches if the secured party has it. If I've got it in my possession, we're good to go. Right, we're done. It's clear. I have it. I have a secured, perfected interest. All right, you be the judge. So Benny Goodman needs money to keep his big band instrument store afloat. He asks his Uncle Art Shaw to borrow $100,000. Uncle Art agrees so long as Benny agrees to use his gold clarinet worth $200,000 as collateral. Right? Benny agrees and gives his clarinet to his uncle. Uncle Art gives Benny a check for $100,000 but forgets to get Benny to sign the document summarizing their agreement. Has a security agreement attached allowing Uncle Art to sell Benny's clarinet if Benny defaults on the loan. All right, first we take a look at it, right? Was there clearly an exchange of items here? Yeah, there was the clarinet as collateral in which Benny clearly has a right to that clarinet, right? And so all good on that front. And then, wait a second, Benny didn't sign anything. However, in this situation, because Uncle Art took actual possession of the clarinet, he didn't have to be in writing. Remember, it can be done orally. So Uncle Art's good to go. He has a perfected security interest in the clarinet. If Benny doesn't pay off the $100,000, Uncle Art can sell the gold clarinet and take $100,000 worth, and then he has to give the rest of the proceeds from that back to Benny Goodman. All right. Value. For security interest to attach, secured party must give some value, right? The secured party is the one, so for example, the air conditioning we talked about for my house, in the scenario we just did before, right, $100,000 is what Uncle Art is giving. He's going to be the secured person in that situation. Future value is okay, right? If the value of whatever the item is going to be in the future, for example, businesses do that a lot, right? I'm in the business of making money, but I'm not necessarily may need to buy some assets now or some items now in order to make my money in the future, right? Future value is okay. That's part of what value is. So a good example of future value might be I get a line of credit for $5 million, right? But I may only use $1 million, but the bank gives you that $5 million. Well, that's still future value, okay? Debtor's rights in collateral. Any legal right is good, but the debtor has to have a right in that collateral. And the earlier one we just talked about clearly is Benny Goodman's gold clarinet. Future property or after-acquired property is okay. What I mean by that is, remember the loan we talked about for the $5 million, and I used the $1 million to go buy a bunch of different equipment, right? That $1 million that used to buy that equipment is after acquired property. That can be part of, we could have made an agreement that if you use $1 million to go buy property, I have a security interest in that property. Proceeds. If then I sell those tractors at some point in time, I now have a security interest in the money that you used to sell, or that you made from the sale, I should say. Perfection. Once the security interest has attached, the secured party is protected against any debtor, right? Other debtors, should be is the other way of saying, right? To protect against third parties, the secured party must perfect their interest. This must be basically telling the world, I have a security interest. So if you want to do a secondary loan off this same property, right? Say Uncle Art has got the clarinet in his possession. Benny Goodman's still trying to get more money. He goes to somebody else to borrow another $50,000 and says, hey, can I have the clarinet? And Benny says, well, my Uncle Art's holding on to it at this point in time, right? He's got control of that. The secondary, this new person for $50,000 is going to be second. So it's only going to be if he sells it and there's $150,000, only way they're going to get their money at least value, right? So this is the idea of saying, I have a security interest, so you loan money, you do something at your own peril. You may not get any, there may not be anything left. Perfection by filing. is one of the ways in which you can perfect it. Usually filing means you do so at some place in which you can then go look it up. So for example, if Uncle Art had perfected by filing, he didn't have to because he had possession, but if he did, then I could go look up and see that Uncle Art has a interest in that for $100,000. I may know that the gold clarinet is worth $200,000, so I can still loan $50,000 knowing that there's a good chance there's going to be some money left over there. That'd be okay. If I'm going to go loan for $500,000 based on it, then there may not be, or $200,000, then I may not want to, right? You can perfect by possession or control. We talked about the Uncle Art. That's how he essentially perfected it. He took possession of that gold clarinet. He was good to go. For perfection of consumer goods, we're going to talk a little bit what that is here in a second and how it can happen automatically. And then there can be perfection of movable collateral and fixtures. I don't want you to know about that. It's wonky and don't worry about it. But it's just another way in which you can secure your interest of movable things. All right. Filing is the #1 way. It's the most common way to perfect. It's done by filing a financial statement. That's a copy. There on the right-hand side is a copy of a typical financial statement, UCC financial statement. The financial statement gives the names of all the parties, and you got to be very specific on the name. You need to make sure usually that you get a full name, right? If you misspell something in the form, that can be detrimental to you later on. If somebody were to look up, and by name is the important part, and if they look up and that name that they have in front of them is not the same name you put on it, their interest may end up being greater than yours. If the collateral is accounts or general intangibles, the filing this UCC statement is the only way for you to perfect, right? Must be filed in the state in which the debtor lives. Filing is effective for 5 years. It has to be renewed within 6 months of that expiration date. If not, you no longer have a secured interest in it. Doesn't mean you don't have an unsecured interest, just means you no longer have a secured interest. Perfection by possession. A secured transaction, a pledge, is a secured transaction in which the debtor gives collateral to the secured party. That's what a pledge is. I'm pledging you, Uncle Art, my gold clarinet for that $100,000, right? And that's what a pledge is, right? Possession can be done with goods. It can be done with negotiable instruments. It generally has to be done with money, chattel, paper. Possession or control has to be done in those areas. Okay. Advantages, notice is very effective, right? It helps ensure that the property is not going to be damaged. If you're Uncle Art, right? If Benny was hard on stuff and he took that gold clarinet and he started damaging it, maybe it's not going to be worth $200,000. You having possession, you know you're going to keep it in good because you got a $100,000 interest in that thing now, right? And if Benny Goodman defaults, you have in your possession, it's easy. You don't have to go, like my air conditioner scenario, go in the middle of the night and unscrew everything and steal the air conditioner, not steal, repossess the air conditioner from my house, right? So it's a lot easier because you don't have to worry about doing repossession. You have to have, when it comes to money, I talked about that before, you have to have possession of that or control of it. Perfection by control, investment property, deposit accounts, all those things have to be done by control. You have to have some document indicating you have control over those documents. All right. Perfection of consumer goods. Again, so now we've talked about the financial statements and how those need to be done. When it comes to consumer goods, the rules change. You don't have to actually follow a financing statement. We'll talk about that. It's called a purchase money security interest. We don't have these as much anymore because we all use our credit cards, and usually there's not an interest by the credit card. We just have to pay the credit card companies back, right? But in the old days, there was a lot more of this type of situation where you would purchase, say, a computer or something directly from maybe a Best Buy or some computer place, right? That transaction that you would have with them would be a purchase money security interest. That's an interest taken by a person who sells a consumer good or advances money so a debtor can buy it, right? It could be a situation where a bank is going to loan you the money to buy that particular computer, and they have agreement with the Best Buy to be the lender for them, and they're going to agree. They're going to check your your credit, and if your credit's good, they're going to agree to loan you money so you can buy that computer, right? Either one. They perfect automatically. You don't have to actually file them. As soon as you've made that transaction, you have a secured interest. You're a secured person later on for bankruptcy. All right, you guys gave me the judge. All right, Captain Jack owns a tropical fish and sea creature business. He's in need of a large tank to show off some of the fish and sea creatures. He gets his old friend Davy Jones to lend him $25,000 for the tank. Captain Jack signs a security agreement with Davy Jones. Thinking tanks are consumer goods, Davy Jones does not file the financing statement. Right? Captain Jack's luck changes as he gets stranded on Tortuga Island in a bad storm after drinking mass rum. Other creditors come in to seize assets due to money Captain Jack owed them. Arguing the tank was a consumer good, thus a security agreement becomes a perfection under a PMSI. Davy Jones believes he has perfected automatically. All right. Is he right? And will he prevail in being able to repossess the tank to sell it in order to cover Captain Jack's default on the loan? All right. The strategy is for Davy Jones to prove to the court that, in fact, that tank was a consumer good. As such, as soon as that consumer good, the transaction for the consumer good was done, it perfected automatically. In this particular case here, I think he loses. I think it would be argued the purpose he was using it was a display tank, so it wasn't necessarily a consumer good. It was becoming a fixture in this particular place, and as a result of it being a fixture, it was not something in which it perfected automatically. It doesn't mean he's not going to get money. They're going to sell the tank, and all the creditors are going to get some portion of this from the sale of that tank under bankruptcy. We'll learn more about that in the next segment. All right, protection of buyers. Generally, once a security interest is perfected, it remains effective regardless of whether collateral is sold, exchanged, or transferred in some way. Buyers in the ordinary course of business. You do need to know this. There are a couple questions on the test, so make sure you do understand what's going on. What I meant by, and I should have come, protection of buyers means the buyers of the item, the collateral, if you will, of that was used for the security interest. I think the book gave some examples of buses that the school was loaned money to go purchase buses. Then later on they sell those buses. The buyer of the buses, right, generally they're okay because now the cash from the sale is going to be what's the perfected interest. So if you're a buyer of those things later on, you're usually going to be okay. Buyers in the ordinary course of business, it means you're absolutely going to be okay, right? Someone who buys goods in good faith from a seller who routinely deals in such goods. The bus situation, maybe not so, because the school bus, that's not ordinarily what they do as far as selling buses, right? I'll give you a good example about this here in a second, but let's talk about what that means. Buyer in ordinary course takes goods free from any security interest, even if it is a perfected security interest. Again, this is why possession or control is important in some instances to avoid this type of a situation. But many times you just can't do that. But a buyer in the ordinary course takes that goods free from any security interest. The person who is the secured party is going to have to figure out some way of getting back their debt if there's a default on that particular debt. All right. Only a buyer in the ordinary course if a seller of the goods created the security interest, right? What I mean by that is, let's give an example of a tree farm. Say, owner of a tree farm gets a loan from a bank. The security interest that the bank is in those trees, right? Or they sell those trees at a later time. If they sell those trees, whatever the proceeds from that would be. If their business is to sell trees to other people, I go and I buy 10 trees from them. I'm a buyer in the ordinary course at that particular case. The bank can't come after those 10 trees that I purchased, right? They can come after whatever money proceeds, but they may not be there anymore. But they can't come after my trees so long as it was done in an ordinary course. All right. Troy owns an art gallery specializing in Greek artifacts. To modernize the gallery, Troy borrows $150,000 from Sparta Bank, which takes a security interest in his entire inventory. Sparta promptly perfects the security interest by filing a financial statement with the Secretary of State. 2 weeks later, Troy sells the famous arrow that struck Achilles in the ankle for $275,000. Helen did not bother to check with the Secretary of State to see if there was any security interest in the arrow that she purchased. 6 months later, the business in Greek artifacts is no longer any good. Troy defaults on his loan to Sparta Bank. Realizing the arrow is gone, Sparta seeks repossession of the arrow from Helen. Sparta proves that any routine check of any financial statements would have revealed that the banks had a security interest in that arrow. Who wins? Helen, right? In this particular case here, Troy's business was primarily selling of Greek artifacts. That means he was a business that was an ordinary course of what he did. Helen was a consumer of that, purchased from them, so Sparta Bank can't come after that particular arrow. They're going to have to figure out other ways in getting that money. All right, buyers of consumer goods, same sort of thing. Again, if this is different though, in the sense that we're talking about what consumer goods are. But again, if it's a consumer good, again, they can't come after. If you're a buyer in the ordinary course of buying a consumer good, you're good to go, even though there may have been a security interest attached to that particular item. Same thing on buyers of chattel paper instruments, because those need to be performed by possession. A buyer purchases chattel paper or an instrument in ordinary course of business and then takes possession, generally takes free of any security interest. So if I later on, right, have whatever it was, which was the original interest, take possession of whatever that is, when it comes to chattel paper instruments documents, I'm free to go. You can't necessarily say, I want that back. Right? Sorry that there's a hesitation in my computer right now. I don't know why. Hope we'll get this thing figured out here pretty quick. It'll stop spinning on me. All right, sorry about any malfunctions there. I'm sure it's something on my end, but so let's get into why do you want to perfect, right? We just got done doing the ordinary course stuff, but understand you'll have a few questions on the test that you kind of want to take a look at. Is it a consumer or is it a business that in the ordinary course would sell something to somebody? Then if you do, you no longer have to worry about somebody coming back and getting it from you later on, like the bank or whatever. All right, so why perfect? The main reason why you would want to perfect is, well, again, you'll see greater detail when you read the bankruptcy stuff, but you protect against others. You have greater priorities over others and any interest they may have in whatever the collateral is. There is a priority among creditors. 3 rules of priority. Party with a perfected interest has priority over party with an unperfected. Makes sense, right? You've already announced to the world, I have an interest in that particular collateral, right? The unperfected person should have looked it up. If neither security party, or I should say perfected their interest, if neither secured party has perfected, then the first interest to attach, we've talked about what attachment is, the first person who's gone through those 3 steps of attachment is the person who gets priority over the person who did it at a later time. Between perfected security interests, the first to file or perfect wins. Exceptions, always caveats in the law, you know that. Deposit accounts, investment properties, letter of credit, all those things, the person who actually has control wins over who merely filed. So if you don't take possession of those items, then you could end up being in a bad situation. Instruments, possession wins every single time, even if the competing secured party attached and filed at an earlier time. And when it comes to instruments, if you're in possession, you win. Default and termination, right? This is where a situation where you either completed your end of the transaction or you didn't, right? You defaulted, you didn't fulfill your obligations. Default means generally the debtor defaults when a debtor fails to make payments due or enters into some sort of bankruptcy proceedings. There are two options upon default. Option number one, take possession of the collateral. Either you're already in possession of it, possession of control, or two, you repossess it. Other thing is to sue for monies owed on the debt. All right, disposition of collateral. You can sell, lease, or otherwise dispose of collateral in a commercially reasonable manner. Right? We talked about Uncle Art selling the gold clarinet. You have to do so to get the most money as you can, and if there's any extra proceeds, you need to make sure that's called a surplus. You need to make sure you get that money to Benny. If it turns out, say, well, let's change the facts a little bit, right? It was a $175,000 loan. It turns out you could only get, the markets on gold clarinets has gone down. You can only get $150,000 from that. Well, that's a deficiency. In some way or another, depending on if you agree that Benny would have to pay any deficiency, then Benny may have to. If there was not an agreement that he would pay any deficiency, then you're left with whatever the collateral, whatever you sold the collateral for. All right, retention or acceptance of collateral. So if third party can keep or retain the collateral for itself as full or partial satisfaction of the debt. In the Benny Goodman Art, Uncle Art situation, Uncle Art could say, I'm not going to actually sell, but I'm just going to keep the clarinet in this situation as for this debt, right? If seeking partial, must notify debtor who can object. If they object, they then may have to sell the item. In that Uncle Art situation, in the original fact pattern, $200,000 would easily cover the $100,000 loan. Benny could say, I object because there's another $100,000 left for me. You need to sell that so I can get my surplus. Can't seek partial satisfaction of consumer goods. If you say, I'm going to keep it, right? In the scenario I said before where $175,000 loan, it can only be sold for $150,000. I'm going to keep it. You say, I'm going to keep it. Well, you can't then turn around and sue for that deficiency. You are stuck with, that's what you end up getting, that's what you get. Now, in a situation called a right of redemption is where a debtor has a right to pay full value, right? Benny could turn around and figure out how to pay the $100,000 real quick so he could get that clarinet. He may want to. That gold clarinet may mean a lot and therefore may figure out a way. That's called a right of redemption. All right, termination. Debtor fulfills the obligation. The secured party must complete a termination statement if they file the financial statement. They have to let the world know the interest in this, my interest in this property is no longer around. The person has paid off. The termination statement is a document indicating the secured party no longer has any interest in the collateral. Usually under the law, again, you don't need to know this. They have certain time periods to get it paid back under the UCC. Those are the time periods there. All right, that's the end of this video. And so, again, I went through it pretty quick. I know it's kind of wonky. I know. I'll put some other stuff out there for you guys. It's the definitions are the key. The attachment process. You need to know the attachment process, and then you need to know why, the importance of it, that the difference between the parties, a debtor, a creditor, a collateral, what all those items mean, and why it's important to perfect your interest. All right. Thank you guys again for watching all these videos, for being so understanding that this is kind of how we had to do this semester. Stay safe. Take care.